Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on today's video. On today's video, we're continuing with part 3 of our 4-part series on the update on the QME regulations. And in part 3, we began part 3 with a discussion of the codes and regulations involved with the QME report. And we started our discussion by talking about California Code of Regulation 9795 as it relates to your reporting of the complexity factors and your billing level of your report. So we handled that topic. And I want to encourage you to follow the suggestions that I outlined in that discussion and follow those suggestions exactly to the letter, the way I described them. The complexity factors simply cannot be better described and better detailed than the method that I outlined for you in that discussion. And then in our last discussion, we talked about all of the labor codes and regulations involved with your review of records. And again, I encourage you to adopt the procedure that I outlined for you in that discussion as well. You know, I continue to see doctors' reports who fail to follow the requirements of the codes and regulations that govern the review of records. And in my opinion, their review of records is poor at best and at most does not qualify as a complexity factor and does not contribute to the higher ML103 or ML104 billing levels. So it's important that you comply exactly with the letter of the codes and the letter of the regulations in constructing your review of records section of your report. And let me just encourage you to make the review of records section of your report an absolute masterpiece, an absolute stunning part of your overall report. It should be impressive. It should be fabulously laid out visually in tabular format. It should be organized in chronologic order. And it should summarize each and every document that you reviewed and relied upon in the formulation of your opinions and conclusions by using bullets, numbers, and tabular format so that it's extremely impressive and visually appealing to the reader. As I said, the review of records section of your report should be a section of your report of which you're most proud. So I encourage you to adopt those suggestions and recommendations as well. For today, in our final part of our 4-part series, today's the final part in part 3 of our 4-part series. And for today, I want to talk to you about a fascinating topic. And it seems to be a topic that sometimes confounds and confuses doctors. And I can say this because I get phone calls from doctors almost on a daily basis with questions and requests as to how to handle their difficult opinions and conclusions as relates to the apportionment. So today, I want to talk to you about apportionment. And apportionment is governed by 2 important labor codes. So I'm going to review those labor codes with you. And I'm going to give you some suggestions as to how you can simplify the thought process that goes into your decision making when it comes to providing your argument for apportionment. So we're going to review a couple of key labor codes, and then I also want to review with you some key citations from the Escobedo decision. And I think that with the combination of the labor codes and some key tenets and principles from the Escobedo decision, you'll have your apportionment determinations mostly whipped. Of course, each case is going to involve some specific and unique details that will have to be taken into consideration. But with a few key principles from the labor codes and from the Escobedo decision, you'll be more than halfway there, because the labor codes and the Escobedo decisions kind of guide us and direct us in the proper direction in providing our apportionment opinions. So these are key principles that all the parties rely upon in reviewing your opinion and your conclusion on the apportionment of the permanent impairment. So let's get right in today to a discussion of the topic of apportionment. And I'm going to go ahead and retrieve a couple of materials, including those labor codes that I referenced, as well as the Escobedo decision. And I look forward to being right back with you here in just a moment as we begin our final discussion in part 3, the codes and regulations involved with the QME report. And today we're focusing our discussion on Labor Codes 4663 and 4664 as it relates to the apportionment of the permanent impairment. Okay, I'm back with you now and have a couple of materials with me that I want to review with you. And let me just preface today's discussion by saying that the topic of apportionment is a huge topic. It's a huge topic. This in no way is going to constitute anywhere near a complete course on apportionment because that would be simply impossible and time prohibitive. I recently went to a California applicant attorneys seminar where the entire weekend discussion was focused on issues related to apportionment. I mean, this was a 16-hour seminar where we reviewed case after case after case to uncover and discover the underlying principles that contributed to the conclusion for the apportionment of the permanent impairment. So apportionment is a huge topic, and there's no way we can fully discuss it here in this brief video discussion. However, there's a couple of key principles that are involved with your apportionment determination. There's a few key principles upon which you can rely and employ when it comes time to sit down and grind your brain over your final opinion and conclusion regarding apportionment. And it seems that when we author our QME reports, it's the causation, it's the permanent impairment, and then of course it's the apportionment determination that really causes us to dig deep and think and concentrate for an extended period of time to come up with a reasonable conclusion that qualifies as substantial medical evidence. So I want to share with you just a few key principles today that you can rely on and that you can employ in each and every one of your cases. And these are principles that are governed by law, meaning they're contained within labor codes. And then they're also governed by case law. And when I say case law, I'm referring mostly and specifically to the Escobedo case. Now, there are other cases over the years that have rendered landmark decisions regarding apportionment, but still it's the Escobedo case upon which we rely for some of the basic foundational principles governing the apportionment determination. So let me share with you a couple of things. Number one is that with regards to the Escobedo case, and we'll talk about several features and factors from the Escobedo case. One of the main conclusions of the Escobedo case is that for your opinion on the apportionment of the permanent impairment to be an opinion that the parties can rely upon and that the parties can actually use in determining the injured worker's benefits, your opinion on the apportionment of the permanent impairment has to qualify as what's referred to as substantial medical evidence. It has to qualify as substantial medical evidence. Now, the opposite of substantial medical evidence is an opinion that's insubstantial. Opinion that's basically worthless. So we're talking about how to create worthwhile opinions on apportionment. So Escobedo said that in order to qualify, your opinion has to be substantial. It has to be what's referred to as substantial medical evidence. And Escobedo defined exactly what criteria need to be present in your opinion in order for your opinion to qualify as substantial. So let's review those. This is relating to your opinion. Now, we're not talking yet about how to formulate your opinion. That seems to be one of the difficulties that doctors encounter, as well as how do I formulate my opinion on the apportionment. We'll talk about that in a little bit. But let's assume that at this point in time you've already formulated and presented and authored your opinion. Well, in order for that opinion to be an opinion that the parties can use and rely on for determining benefits, it must, number one, it must be framed in terms of reasonable medical probability. Reasonable medical probability. Now, this is a fabulous phrase. This is probably the most useful phrase that we'll ever encounter in the work that we do. Reasonable medical probability. So what this means is that when you provide your opinion on the apportionment of the permanent impairment, you provide your opinion within reasonable medical probability. Reasonable medical probability. That's different from medical certainty or scientific certainty. And in these cases, it's almost never possible to be exactly 100% certain about the apportionment of the permanent impairment. It's not possible. These are gray areas for which there's no absolute correct determination. How could you scientifically certain apportion the permanent impairment 37.82% to the industrial injury and 63.29% to other factors? It's not possible to be exactly medically and scientifically certain, but we provide our opinions as close as we can, which is within reasonable medical probability. So when you provide your opinion, phrase it in terms of reasonable medical probability. That in and of itself will begin to qualify your opinion as substantial. Number two, your opinion must not be speculative. Other cases, I think it was the Brody case and the Zemke case, said that the opinion cannot be based on conjecture, surmise, or speculation. Escobedo used the term speculation. So your opinion must not be speculative. You cannot speculate. And you might simply say in the body of your opinion that the reason I say this is because to say otherwise would involve speculation, something like that, and indicate to the parties that you're not speculating. Okay? Number three, the opinion and conclusion on the apportionment of the permanent impairment must be based on pertinent facts. Pertinent facts. So in your opinion, in the body of your report, use language that elaborates on the pertinent facts that contribute to your opinion on the apportionment. Spell out for the parties what are the pertinent facts upon which you rely. Okay? Number four, it must be based, and this is important, it must be based on an adequate examination and history. And you've heard me talk about this at great length and in great detail, and this is something that I continue to grind on, and that is your history should be fabulous, should be fabulous, it should be thorough, and it should uncover and discover as many facts as any provider in the entire history of the claim has been able to uncover and discover. You should be a fabulous historian, and so your history should be a masterpiece. Also, your physical examination should be flawless. It should be a masterpiece. It should be detailed. It should be thorough. It should be accurate. It should include every single possible objective test that are described in the AMA guides. Your physical exam should be a masterpiece. And I tell doctors this all the time. The physical exam is the exclusive domain of us as doctors. It's basically our work product. And your work product should be a fabulous representation of you and your attention to detail and your quality, the quality of your work. So it must be based on an adequate history and an adequate examination. And one of the strategies of either the applicant or the defense side is to suggest that perhaps your physical examination is not adequate. Is not adequate. How could a physical examination not be adequate? It could be adequate if it does not contain the necessary physical exam procedures and the necessary measurements upon which you derive your conclusions. So that is a point of attack of the parties to suggest and to demonstrate that your physical examination is not adequate. And I've reviewed many doctors' reports who I can tell you the physical examination is not adequate, and that's a euphemistic term. That's a softened term to suggest that some doctors' physical examinations are terrible, but let's just say that they're not adequate. So I encourage you to improve the content and quality of your physical examination, if for no other reason than to support your opinions and conclusions. And then finally, and this is a key point of Escobedo, and this is where most doctors fall off, and this is where their opinion on apportionment fails to meet the standard of substantial medical evidence. Number 5, it says that it must set forth the reasoning in support of its conclusions. Let me say that again. It must set forth the reasoning in support of its conclusions. And the opposite of that is not setting forth the reasoning for your conclusions. The term for that is that your conclusion is conclusory. Conclusory means that you simply cite the conclusion but fail to describe the reasoning behind the conclusion. It's a conclusory opinion only. And many doctors provide conclusory opinions only. And a conclusory opinion that does not detail the reasons that support the conclusion is not substantial. It's conclusory only. See how the use of these terms, or see how these terms are used? So in practical matters, what that means is that in the body of your report, when you provide your opinion on the apportionment of the permanent impairment, and let me just give you an opinion. Let's just say that you conclude that 40% of the permanent impairment is due to the industrial injury, and 60% of the permanent impairment is due to other factors, period. That part of the opinion is the conclusory part of the opinion. Now, in order for that opinion to qualify as substantial medical evidence, you would then continue in the body of your report by saying something similar to the following. Reasons in support of this conclusion include, new line, number 1, and list your reasons why 40% of the permanent impairment is due to the industrial injury. When you've completely elaborated on why 40% is due to the industrial injury, then you would elaborate on why 60% is due to other factors. Now, this section, the section that represents your reasoning, your reasoning must be impressive. It must be irrefutable. It must be based on the pertinent facts. It must be based on your brilliant examination. It must be based on your thorough and in-depth history. It must be irrefutable. And when you review your report prior to sending in your report, review your reasonings that support your conclusion. And look through your reasoning and ask yourself, where is the weak spot? Where is the hole? Where do I leave myself exposed in my reasoning? Because Any weak spot in your reasoning is going to be questioned and investigated by either the applicant attorney or by the defense attorney or by the claims administrator. Okay? So your reasonings must be so compelling, first of all to you, and then also to the parties, must be so compelling that they're irrefutable. They're irrefutable because it's based on all of these criteria that qualify your final opinion as substantial. Okay? So the first basic rule in providing for your apportionment opinion is to make your opinion substantial, first of all. Okay? Let's go over a couple of other things. With regards to Labor Code 4663 and 4664, these labor codes are the codes that govern the decision-making process regarding apportionment, and they give us some key directions as the evaluating doctors. They give us some key instructions. So I want to read these word for word from the text of these labor codes. So let's begin with Labor Code 4663. It says, a physician shall make an apportionment determination. Okay, any report that includes an opinion on permanent impairment must also include an opinion on the apportionment of the permanent impairment. So the code says, a physician shall make an apportionment determination by finding what approximate percentage of the permanent disability was caused by the direct result of an injury, and what approximate percentage of the permanent disability was caused by other factors, both before and subsequent to the industrial injury, including prior industrial injuries. And I get calls from doctors all the time asking me how to handle a case where the examinee has had a prior industrial injury and the instruction is contained exactly within the text of Labor Code 4663. Okay? So, a couple key points from 4663. Number one is that it says that we're allowed to provide approximate percentages. Approximate percentages. What's the opposite of approximate? The opposite is exact. And the legislature that wrote this law, they understood the difficulty that we would encounter as evaluating physicians, the difficulty in providing for exact percentages. It's not possible. It's impossible. That's why the law allows us to provide for approximate percentages. So when you provide your opinion on apportionment, phrase it in terms of approximate percentage. That might go as follows. In my opinion, within reasonable medical probability, 40% of the permanent disability or impairment, approximately 40% of the permanent impairment is due to the industrial injury, and approximately 60% is due to other factors, and elaborate on the other factors. Prior industrial injury, pre-existing degenerative change, presence of a spinal anomaly, whatever. But phrase your percentages, your numeric percentages, in terms of approximate percentages. Now, the code allows for us to use approximate percentages, but our obligation as medical evaluators is to give exact numbers. Now, I used to write my approximate percentages in terms of a range. So, for example, I would say, in my opinion, within reasonable medical probability, approximately 30 to 40% of the permanent disability was caused by the industrial injury, and approximately 60 to 70% was caused by other factors. And I would provide my approximate percentages in terms of a range because I felt that that was the best I could do as an approximation, since it could not be exact. Well, I later found that the parties cannot use a range of numbers in order to resolve the case. They need an exact number. However, we need to maintain it and retain it in our mind that the exact number is still only an approximation. So still provide an exact number, but phrase it and reference it in terms of an approximation as allowed by the letter of the law. Okay? So that's one thing. And then let me read to you Labor Code 4664. This is a fascinating section of the law. It says, the employer shall only be liable for the percentage of permanent disability directly caused by the injury arising out of and occurring in the course of employment. The employer is only responsible for that part of the permanent disability that's directly caused by the industrial injury. They're not responsible for the other causes or the other contributors to the permanent disability. They're only responsible for what they're responsible. Now, one of the key tenets of the Escobedo decision is that it's the obligation of the claims administrator, and it's the obligation of the defense attorney to prove the percentage of apportionment that's due to other factors, and it's the obligation of the injured worker and the applicant attorney to prove the percentage of permanent impairment that's directly due to the industrial injury. So when you provide your opinion on the apportionment of the permanent impairment, you can bet that the applicant attorney is going to question you on the portion of your opinion that directly relates to the industrial injury. And you can bet that the defense attorney is going to question you on the approximate percentage of the permanent disability that you ascribe to other factors. Each party is going to want to maximize the approximate percentage that you apportion to those two ends of the apportionment spectrum. On one end is the industrial injury, and the other end of the spectrum is all other factors. And it's the defense that's going to attempt to prove apportionment to other factors. It's the applicant attorney that's going to want to prove the percent of permanent impairment due to the industrial injury. So review your approximate percentages related to apportionment, and review your opinion from the perspective of these two parties, from the perspective of the applicant attorney and from the perspective of the defense attorney, and ask yourself, where is each one of these parties going to attack me in order to maximize their particular percentage? This comprises largely the entire substance of most depositions. Many depositions, the entirety of the deposition focuses around the apportionment determination, with each side trying to maximize the approximate percentage due to either the industrial injury or due to other factors. So keep that in mind, and keep the perspective of the other parties in mind as you provide for your approximate percentages. And again, they only have to be approximate, and phrase them in terms of approximate percentages. Okay, so that was section A of 4664. Let's read section B now, and this is a fascinating section of the law that gives us so much direction and so much instruction. It says, if the applicant has received a prior award of permanent disability, so they're talking about applicants who have had prior industrial injuries, have gone through treatment, have been declared to be permanent and stationary, have probably had a qualified or agreed medical evaluation, or have been declared to have permanent impairment by the primary treating physician, and then they received that permanent disability award. It says that it shall be conclusively presumed that the prior permanent disability exists at the time of any subsequent industrial injury. This presumption is a presumption affecting the burden of proof, and this section says so much. So let's review this. This is talking about examinees who have had a prior permanent disability award. Let's say we have an examinee who had a prior permanent disability award in 2010, okay? And the examinee goes back to work in either the same job or a different job or whatever. And they return in 2015 with another injury to the same part of the body. Let's say perhaps the lumbar spine. So they return in 2015 with an injury to the lumbar spine. And when they sit down in front of us and we evaluate them, they tell us about their subjective complaints with the lumbar spine. We do our physical examination and we find the objective tests and measurements related to the lumbar spine. And what 4664B tells us is that at the time they had the subsequent industrial injury in 2015, they already had a bad back. They had a documented bad back. They had a permanently impaired bad back. They had permanent disability related to their back. It persists and exists into perpetuity. That's the language of the letter of the law. So when this examinee comes to you in 2015 and they tell you about their lower back pain and their lower back symptoms, this is not a surprise that they would have lower back pain and symptoms, because according to the law, the permanent disability persists and exists at the time of the subsequent industrial injury. And when they go through their physical examination and they're stiff and and they have all these positive objective findings, this is not a surprise, because we know, according to the letter of the law, that they already had a bad back. They had a permanently impaired bad back. Now, the letter of the law says that this presumption, the presumption that the permanent disability exists and persists, is a presumption affecting the burden of proof. See, it used to be before the enactment of 4664 that the examinee could demonstrate that they had rehabilitated themselves, that after they received their permanent disability award, they then went to the gym and exercised, they lost weight, they used chiropractic and massage on a prophylactic basis, they used proper lifting techniques, and in the time between when they received their permanent disability award and the date of the subsequent industrial injury, they had no medical treatment at all related to their back. They could demonstrate that they had rehabilitated themselves and that they had returned back to baseline function for the lumbar spine. Well, this new section of the law, which passed in 2004 with the enactment of Senate Bill 899, said that no, there is no rehabilitation back to baseline. If you have a permanent disability award due to a lumbar spine injury, you have a bad back administratively forever. And that in order to qualify for new additional permanent impairment or new additional permanent disability, you only qualify for the new worsening of the lumbar spine. So when you have these cases that come to you, your job and your obligation is to investigate the worsening, only the worsening, because we know already that they came into the injury with a bad back. It's stated in the letter of the law. The permanent disability exists at the time of any subsequent industrial injury. So they already had a tricky back, a bad back, a weak back, a degenerative back, an impaired back. Now, it says that this presumption is a presumption affecting the burden of proof. So that indicates that you can argue for a rehabilitation of the spine back to baseline. But the question that I pose to you today is, upon who does the burden of proof rest? And it's my opinion that the burden of proof does not rest with us as qualified medical evaluators. Now, it doesn't state in the letter of law upon whom the burden rests. And there have been times in the past where I have argued that the examinee has rehabilitated himself back to baseline by using some of those criteria that I exactly discussed just a minute ago, that they went to the gym, they worked out, they lost weight, they used chiropractic, and most importantly, that the medical records failed to document any significant treatment for the lumbar spine in the intervening years. These would be criteria suggestive of a rehabilitation. But it's my opinion that it's not the doctor's, it's not the QME's job to argue a rehabilitation. Rather, it's the job of the applicant attorney upon whom the burden of proof, and it's the examinee upon whom the burden of proof rests. So, with regards to providing your opinion on the apportionment determination, the approximate percentage should take into account any prior permanent disability award that the examinee had. So what's your obligation in these cases? Your obligation is to examine the injured worker, to come up with the permanent impairment rating at the date of your evaluation, the date and time of your evaluation, and then to look at the prior permanent disability award and the prior physical examination upon which the permanent disability award was predicated, and assess for worsening. For any new worsening, the examinee certainly qualifies for new permanent impairment or new permanent disability. In many cases, the examinee demonstrates themselves to have improved function over the prior permanent disability award, over the prior physical examination upon which the disability award was based, and so they would not qualify for a new permanent impairment rating because they're actually better than they were. They're actually better than they were. Now, some doctors ask me, well, does this apply to a compromise and release? Compromise and release is not a permanent disability award, and the letter of the law specifically relates to a prior award of permanent disability. So the letter of the law does not apply to compromise and release. But it's my opinion, and this is the way I handle my apportionment determinations, it's my opinion that a compromise and release is roughly analogous to a permanent disability award because the compromise and release settlement is based upon either a permanent and stationary physician's report, qualified medical evaluator's report, or an agreed medical evaluator's report, and those physical examination findings form the basis of the compromise and release award. So those physical examination findings of that prior evaluator are significant, and we should review those, and you should review those when it comes time to providing your final opinion on the apportionment. It's my opinion that if the examinee accepted a compromise and release, those physical examination findings, like a permanent disability award, persist and exist at the time of the subsequent industrial injury. Now, that's how I handle those, and there's nothing in the law that prevents the handling of the apportionment determination that way. And I'm not familiar with any case law that prevents it to be handled that way. If you are familiar with case law that prevents you from considering a compromise and release to be roughly analogous to a permanent disability award, please share that with me, and I will modify my procedures in the future, and I'll modify my teachings to other doctors. But that's how I handle that, and that's how I suggest you handle that as well, at least with your initial report. And then if the applicant attorney or defense attorney questions or challenges that, later on you may change or modify your opinion, but that's at least how I handle it initially. Okay? And then, so that's Labor Code 4663 and 4664. Let's finish up with one more key idea relating to apportionment. And this revolves around the mechanism of the injury. As I said before, I went to an applicant attorney seminar a couple years ago, and the whole 2-day discussion was about apportionment. We must have had, I don't know, 20 different speakers. And really, the take-home message from the entire seminar was that apportionment determinations largely rest upon the mechanism of injury. And this comes directly from the Escobedo case. Now, if you're not familiar with the Escobedo case, I have it available for you in its entirety. And you'll simply be able to click a link on today's video, on today's blog discussion, and you'll be able to access the Escobedo decision. But the Escobedo case involved a female who had injuries to her bilateral knees. She injured her left knee in a fall. She injured her right knee as a compensable consequence to the injured left knee. And she developed symptoms of the right knee almost immediately after the left knee injury. So the result of compensating and limping and struggling around with the left knee very quickly overwhelmed the right knee, and the right knee became symptomatic. Well, after all medical treatment was done, Escobedo had a meniscectomy procedure on the left knee, and she had conservative treatment on the right knee. And the evaluating physician apportioned 50% of the permanent impairment to the industrial injury and 50% to degenerative arthritis of the knees. And after much discussion and debate and appeals, the apportionment determination and opinion was upheld. And it came down to the mechanism of the injury. The evaluating doctor opined that permanent impairment of the right knee, the compensable consequence knee, was largely related to pre-existing degenerative arthritis of the knee. And it was only partly related to the industrial injury to the left knee. And it came down to the mechanism of injury, and the doctor opined that because the mechanism of injury was what he referred to as trivial, who falls from a scaffold flat onto his back. A fall from a scaffold flat onto your back is a severe mechanism of injury, and I don't care how old you are and whether you have degenerative change in your back or not. This is going to cause a serious injury and can leave the person, the injured worker, with severe long-term permanent impairment, regardless of age and regardless of condition of the spine. So I encourage you to classify the mechanism of injury with each of your cases, mild, moderate, or severe, and use the mechanism of injury as a basis for providing your apportionment approximate percentages. It's a key tenet from the Escobedo case. So this goes back to your history-taking skills. Investigate, investigate, investigate the mechanism of injury, because certainly the mechanism of injury is later going to come into question should your apportionment determination be challenged, either by way of supplemental report or by way of deposition. And you want to have the facts of the mechanism of injury on the tip of your fingertips and on the tip of your tongue, and you want to be familiar and fluent with the mechanism of injury. You want to be prepared to defend your apportionment determination in terms of and in light of and because of the mechanism of injury. Okay, so key point. Always focus and investigate on the mechanism of injury. Okay, so let's provide some concluding remarks. And that is that the apportionment determination is very seldom an easy conclusion in our reports. It's usually an opinion and conclusion that requires that we bring together all of the details and information of the case. And we use all of the relevant history facts and all of the relevant facts from the physical examination to arrive at a reasonable and substantial opinion on apportionment. And it's the applicant's burden to prove the percentage of the permanent impairment that's due to the industrial injury. It's the defendant's burden to prove the percentage of apportionment of permanent impairment due to other factors. So your opinion on this is going to be challenged. So when you prepare your opinion, prepare it in a way that is substantial, that is impressive, and that's irrefutable, and that incorporates as many of the relevant facts and relevant physical exam findings as possible so that your opinion is irrefutable. Now, I know apportionment is a huge topic, and I'm going to be getting phone calls over the next several weeks saying how to handle this case and how do I handle that case. And I hope these basic principles will give you some direction in arriving at opinions that you feel confident with and that you feel comfortable supporting, either by way of supplemental report or by way of deposition, should it ultimately come to that. Okay, so doctors, I hope this helps you. I look forward to being with you next week, where we'll begin part 4, our concluding section in our 4-part series on the update of the QME regulations. Next week, we're going to conclude the program by talking about the codes and regulations that are involved with the submission of our QME reports to the parties. And we'll also talk about the forms that are required to be submitted with our reports based upon which party we are addressing. So I want to thank you for taking the time to join me on today's video. Look forward to being with you on future videos as well. And for now, I'm wishing you best of success in your career as a qualified medical evaluator.